Good morning.
All right. All right. Testing. 1, 2. Got to turn it on first. Can everyone hear me? Fantastic. Okay, so we do have some coffee and snacks over here. If you haven't got some, now's your chance. Um, Thank you so much for coming. My name is Jacob. I'm the philanthropic advisor for the Catholic Community Foundation for the Diocese of Phoenix. We serve the whole diocese from down in Gila Bend all the way up to northern Arizona to Scenic and Grand Canyon. We serve the whole diocese. I get to be on the road a lot, serving folks like you. I think my next stop will be Lake Havasu City, Prescott. These are my next two stops. Anyway, I want this to be interactive. I want this to be enjoyable for you. If you have a question, please feel free to raise your hand and stop me. I will be presenting the TaxSmart philanthropy piece as well as the Catholic medical directives and funeral planning piece. And then Lisa, who is an estate planning attorney who serves on our board, will be presenting the back half of the presentation. She has very, very generously volunteered to come up here, so thank you, Lisa. I'll go ahead and get started. A quick note about who we are and what we do. Our mission officially is that we encourage compassionate charitable giving to provide sustainable support for those who serve our community. What does that mean? A little louder. Okay. What does this mean? We work to make sure that your diocese, your parish, and your nonprofit organizations that you like to support can survive forever till Christ comes again, is what we like to say. What that means is we hold endowments for a lot of parishes. We also work with individuals to set up their own long-term planned giving plan in order to make sure that your specific interests can be supported after you pass. So that looks different for everyone. I'll give you a couple examples here as we go along. The Catholic Community Foundation is a Catholic organization. We do have canonical status from the diocese and from Rome. We look to separate the assets directly from the diocese and directly from the parish in order to protect them. Now, who loves taxes? Answer is usually no one. There are a couple strategies that folks have when it comes to giving to make sure they're giving effectively and efficiently. Now, I should say, I'm not a CPA. I'm not a tax advisor. It should not be construed as tax advice. However, here are a couple things that we think are relevant to you. Number one, stop writing checks. Why should you stop writing checks? Because usually you can give other assets which make more sense from a tax perspective. When you say stop writing checks, it's referring to cash, right? A better way to give would be to give appreciated assets. There are physical appreciated assets like jewelry, like a boat, like land that you don't use. There's also things like stocks. Generally speaking, these make more sense to give than just cash. If you are in a position to give, generally speaking, consider giving one of these assets first. Now, St. Giovanni Vianney is very, very advanced. Some parishes are not, some nonprofit organizations are not. One of the things that we can do is to help liquidate your assets so that you can give them to the parish or to your favorite organization. Now, there are a few different things to consider here. One is the idea of bunching your giving. Now, you all generally understand how this works, I assume, but most of the time, folks will take what's called a standard deduction. If there's a way to not take a standard deduction, rather to itemize your giving, it's worth your consideration. One thought here is that you could make a single large gift once every 5 years or 4 years or whatever makes sense for you, and then slowly over time give those assets out having already made the gift. This allows you to itemize for 1 year, theoretically, depending on your situation, saving you money on your taxes. How do you do this? Generally, you do this through using a donor-advised fund. The Catholic Community Foundation does offer donor-advised funds. We have a fee version, which is the traditional version, and a no-fee version, which it sounds does not involve a fee. Unlike our competitors, the Catholic Community Foundation's donor-advised funds are fully invested in Catholic organizations. They are fully invested in Catholic responsible investing. Our investment strategy is taken directly from the USCCB. Nothing that we do violates their policies rather. This is an easy way. The donor advised fund, yes.
Can you step back and explain what a donor advised fund is?
Absolutely.
What was the question?
Father asked what a donor advised fund is. Father knows what a donor advised fund is, but he wants us to make sure we all understand. A donor advised fund is similar to having a private foundation, without the cost, without the hallmark, without the tax implications. It's really, you make a gift to Catholic Community Foundation or to whoever holds your donor advised fund, and then you get to essentially use that as a charitable checking account. Anytime that you have a gift that you want to make, you get to log into your system or give us a call and say, please make a gift to St. John Vianney Parish or whatever organization you want. The caveat there is that we cannot make gifts to organizations which directly violate teachings of the Catholic Church. So the obvious one is Planned Parenthood. There are also other ones such as hospitals and organizations which do stem cell research and things like that. So beyond that, we're pretty permissive as long as it's not directly violating teachings of Holy Mother Church. Yes?
Are there age restrictions on donor advised funds?
On donor advised funds, there are not.
So you can have money taken out of an IRA?
Have money taken out of an IRA.
And you're under the age of 70, are you permitted to do that?
I see. So you can't use it as a QCD. You are able to open a donor advised fund regardless of your age, but you can't fund a donor advised fund using a QCD. There is another way to do something similar with your IRAs once you're past the age of 70 and a half, but you cannot use it as a QCD. Yes?
You mentioned that you had fee and no fee. How does that differ from the Arizona Community Foundation? I'm not sure when you say a fee or no fee.
Yes, good question. So I'm not sure the structure of Arizona Community Foundation. However, the traditional donor advised fund, which is the way that your Fidelities will do it, or your Bank of, I'm so sorry. Your Bank of Americas will do it, your Fidelities will do it. Assume ACF will do is they'll charge a 1% fee to invest it.
For the individual, you're saying, not the church.
Right. For your specific assets in your specific donor advised fund. Now, usually the investments perform better than the 1% fee, so you never really feel the hurt of that 1%. The Catholic Community Foundation has another option, which is to have your assets just sit there. They won't be invested if you put $100 in today and don't touch it for 50 years, they'll still be $100 in 50 years, right? So that's a downside, I suppose, depending on your position. But on the other hand, we're not charging any fee on the assets. Now, to your question about required minimum distributions, if you're 70.5 and older, this is a different way to give. This is separate from the donor advised funds, is the idea of using your required minimum distributions as QCDs. QCDs is qualified charitable distributions. It's essentially, once you hit 70.5, you are permitted to give your assets out of your retirement accounts directly to qualified charitable organizations, such as St. John Vianney Parish. This is nice because typically with your retirement accounts, if you were to take assets out, you would be taxed as income for those assets. So if you're in a position where you don't necessarily need your RMD every year, consider making a QCD. This can be given directly to the parish without using us. However, if you want to support St. John Vianney's endowment, or if you want to fund a charitable gift annuity, you can work with us to do that. Now, what is a charitable gift annuity? Charitable gift annuity, as I'm sure some of you are aware, is a vehicle which allows you to make a gift to a organization, either with an IRA or with cash or with a taxable investment account, really whatever you see fit. You will work with us to find a specific rate of return of payment that you would receive guaranteed every year or quarter or month, depending on your preference. And then upon your passing, those assets would be sent to an organization of your choice. In this case, St. John Vianney Parish. Questions there? Now, moving on, there are a couple different considerations when it comes to using your will. One big consideration here is that oftentimes your children do not share your faith. And so if you want to ensure that your most important organizations are supported, the best way is to support them directly through your will. Now, one interesting stat that we heard recently is that though the number of donors are decreasing, the total number of donations is increasing. The dollar value of those donations is increasing. This is probably due to the size of different generations. The thing to consider there is that given the size of the church, it's declining. This will not continue forever. So we do need to make sure that we are supporting Holy Mother Church while we are able to. Now, I'm going to go ahead and move on to this slide, which shows how an estate might look. Lisa will get into the weeds here in a second. This is just an example. If you do want to support your parish or your favorite charity, one way to do it is to just divide it up and add it as a separate beneficiary. So instead of 3 beneficiaries, you would have 4, with 1 being your favorite charity. Now, upon your passing, it would be prudent to reflect on which assets you want to use to support your children, your family, and which assets you want to use to support your parish. Because of the way that different assets are taxed, it's important to consider that if you were to give assets from a retirement account to a child, when they started to use those assets, they would be taxed on it just like you're taxed on it when you take it out. However, if you were to give assets that have that cost basis step up, those assets they're more tax advantaged for individuals to receive. So, again, talk to your tax. Yes?
Can you give an example of non-qualified assets?
Yes, real estate would be the best example there. And then if you have a non-retirement investment account, and you hold one share of a stock that you bought for $2, and when you pass away, it's $15, and you pass that on to your heirs, your heir could receive, would have the cost basis being $15. So if he were to sell it for $16, he'd only be taxed on a $1 capital gain. Make sense? Perfect. Now, a couple different ways to deploy your charitable plan. You can set up your own family endowment. You could set up the donor advised fund we talked about earlier, or you could use that charitable gift annuity. We spoke about most of these earlier, although I will say that the family endowment is something that you can set up with us or with another organization if you so choose, and you can specify exactly how you want your assets deployed. You can say in your will, for example, I leave my assets to $1,000 to the Catholic Community Foundation, and then you come to us, you write up your endowment plan, and you say, actually, I want these assets deployed 5% to St. John Vianney Parish, 5% over to Immaculate Conception, et cetera, et cetera, et cetera. We did just talk about endowments here. The one thing on this slide to mention is that endowments are meant to be sustainable. We are required by law to invest endowments differently than we were to just an unrestricted gift. The idea is that we want these assets to survive for eternity. So if you were to give a donation directly to a parish or to a organization of your choice, they essentially have the opportunity to do whatever they want with it. If you were to give it to an endowment, you have our assurance that it would be invested in such a way that it's slowly given out over time so that it lasts forever. There's also an opportunity here to use your family members as the advisors of your assets upon your passing. This is something good to consider because you do have individuals in your life who you want to see be more charitable or you want to see more involved in philanthropy. Using them as a advisor upon your passing is worth your consideration. All right, that brings us to the end of the tax-smart giving portion. Does anyone have questions there before I move on? Yes. Remainder. Certainly. So charitable lead trust and charitable remainder trust, they're two different variations of the charitable gift annuity, essentially. The charitable remainder trust is essentially a gift that you make either now or upon your passing that for a set period of time or set dollar amount supports one of your heirs, and then upon the reaching of your specified amount or specified time, the remainder of those assets would go to an organization of your choice, and then essentially a charitable lead trust is exactly the opposite, which is that upon your passing or upon the time that you create the charitable lead trust, the organization that you choose would receive a set dollar amount, and then one of your heirs would receive assets for a set period of time after that. Yes?
If somebody wanted to give something during the lifetime, to receive the tax benefits, what would be a good method of doing that?
Sure. So it does depend on your situation, but generally speaking, the charitable gift annuity is the simplest way to accomplish what I think you're asking about. I'm sorry, the charitable gift annuity. There would be a dollar amount that you say, I'm going to set up a charitable gift annuity for St. John Vianney Parish. It's going to be $10,000, for example. If you were to set that up, I would come to you and say, okay, here's how much of this would count as a gift, and here's how much you'd receive quarterly, annually, monthly, in return from us, guaranteed. Assuming that was amenable to you, you would say, okay, great. You get the tax benefit of having made a gift of part of that amount, and then you also receive the benefit of receiving quarterly, monthly, annual gifts, payments from us. Does that make sense?
So using your example, somebody gives $1,000. How much of that will count as charitable giving purposes? And how much of it will come back to you if
So the charitable gift amount does depend on several different factors, but I've generally seen it be about 1/3. And then the amount you'd receive is based on the Fed rate, on interest rates. So right now, it is relatively high. I've seen folks get offered anywhere from 5 for a 2 life, all the way up to highest I've seen is 7.5%.
what if it was an asset like a piece of land?
That would take a little bit longer to set up, but it could be completed. Yep. Yes, of course. All right. We're going to move on to planning your Catholic funeral. I know Father has a couple words about this, but I'll briefly say that, one, we do have a legacy planning guide that I'm happy to offer to anyone who has interest in this specific thing. Come see me after the seminar, and I'll make sure we get one to you. The other thing to consider here is that, again, unfortunately, oftentimes we see that people's heirs are not Catholic. If you were to pass away unexpectedly and they were to be dealing with the grief of you passing, they might not know all of the specificities of a Catholic funeral, so it is worth considering ahead of time. Perhaps you'd want to have an obituary written before you pass. Perhaps you'd want a specific photo. Perhaps there's specific songs you want sung at the funeral mass. These are all things that may be worth your consideration now, even if death does seem far away. Father, do you have anything to add there? Yes, certainly.
At St. John Vianney, we are developing a way to help people with this more directly. I'm going to pass this around. You can sign it if you like, and in the next couple weeks, you'll have a chance to meet with a small group of us, myself included, and begin to talk about these kind of things, planning your funeral, but also just looking over if you have a medical directive, and seeing just what your end of life plan looks like. We happen to be doing this with Deacon Dennis today. He asked us to do that. Father Glenn and I and Tim are going to sit down with him. And soon we're going to have a way for parishioners to sign up to come in and do this with us. We think it's a need in the parish and something that can help people to have a plan and to just be at peace with the plan that's in place. So thank you.
Thanks very much, Father. My final slide is essentially something we already talked about, which is advanced medical directives. Sounds like Father will help you with this directly, which is fantastic. The idea here is wondering, do I have a complete understanding of Catholic social teaching when it comes to medical directives, specifically around ending death? It's a thorny subject. It's wonderful, again, that you have support from your pastor in figuring this out. highly recommend that you consider speaking with him about that. I know there is a Catholic funeral home, or rather a Catholic cemetery over in Cottonwood, and then I also know that there are several trusted funeral homes around town. Now, with that, I'm going to pass it over to Lisa, who's going to talk about the estate part of our presentation. Thank you so much for your time.
Thank you. Good morning, everyone. Can you hear me okay? Okay, great. Well, thank you for having me today. My name is Lisa Riley Payton. I am a tax and estate planning lawyer in Phoenix, Arizona at Frazier, Ryan, Goldberg, and Arnold. We specialize our whole firm in just tax and estate planning. We all do different specialties within that. We have someone who just does guardianships, conservatorships, elder law, property taxes. I specifically do estate planning and tax planning. So hopefully I'm here to just give you some information about some basic estate planning techniques today, different documents, what do they mean. And I am on the board as well, so I do help people with Catholic-based estate planning. Also, I do want to make this interactive, so please just raise your hand if you have a question, and hopefully you'll learn something today. So what happens if I don't have an estate plan? So if you don't have an estate plan, and it's nothing to be embarrassed about, I represent people that come in from very small estates to very large estates that very successful and have family and have charities in mind, but sometimes I think it's hard for people to do this. It's a difficult process, and we understand that. And so if you don't have an estate plan, your assets are going to be passed on through what we call intestate succession. And that's under the laws of the state of Arizona for intestacy. And what that looks like is this. If you're married, everything would go to your spouse. If you're not married but have kids, then everything would go to your children. If you're not married, do not have kids, and your parents are still living, it would go to your parents. If they're not living, brothers and sisters, then nieces and nephews. So that's the intestacy tree. And sometimes people might say that's why they haven't done estate planning. Well, I'm married, it goes to my spouse. That's okay, but what happens if something happens to both of you? Also, through intestacy, you're not making any plans for your church or for any other charitable organizations. Also, if you don't have an estate plan, one of the major things with younger families I'm dealing with is that your last will and testament actually names the guardian of your children and conservator, which is very important. So let's talk about what is a will. And this is not a living will, that's different. This is a last will and testament. So a will is a legal document that's going to say who is going to be named as your personal representative, or sometimes known as your executor of your estate. And it's also going to talk about who, basically, how is your property disposed of upon your death. Now, there's a common misconception that a last will and testament itself avoids probate. It does not. It does not avoid probate. Everybody needs, even if you have a trust, everybody still needs a last will and testament to name the personal representative of your estate and to dispose of your personal property. But this alone does not avoid probate. And it is revocable and amendable until your death. One thing I wanted just a caveat here that's very important, if you can look at these statistics, there's a lot of people, as you can see, it's very common. A lot of people don't have a will, but I think once people understand the benefits of setting up a plan, they can see that it's very important. Another thing that's important about a last will and testament in Arizona law, again, even if you have a trust, you're still going to have a will for your personal property, but Arizona law says that if you have a personal, we call it a personal property memorandum, your last will and testament will reference this personal property memorandum and say, my personal representative should look for a personal property list at my death. And if I have one, it will be honored. You can have a personal property list in your own handwriting. The rule or the law is it either has to be in your own handwriting, or if it's an Excel spreadsheet or Word document, it must be signed and dated by you. And that is valid. Things get very tricky when people write their own will. That's called a holographic will. And there's a lot of requirements, 2 witnesses, a notary, but this personal property list, you can have that and that will be honored. Keep in mind, I see this happen a lot. This is things without titles. You can't say my land, my real estate, my car, my Chase bank account, because what do those have? They have titles. Those people have directions on where those go at the end of your life. But my jewelry, my china vase that's a family heirloom, you can do that. Did you have a question? I didn't know. Did you? No? Okay. So what the will accomplishes is it basically will, if probate needs to be opened, it will tell the court basically who's supposed to be the personal representative, how are your assets going to be distributed upon your death. So a will, just to give you a good example, not everybody needs a trust, but wills, a standalone will, alone does not avoid probate. But let's say I have someone who comes in who's maybe 70 years old, widowed, no children, no grandchildren, and they say, I have a house and a bank account. And they're going to my adult sister, and that's it. It's as simple as that. Well, in that case, a will is going to be very important as far as personal property. Maybe she'll name her sister as personal representative or executor. But in combination with the will, we could do a payable on death on the bank account to her sister, and we could prepare a beneficiary deed to transfer that home to the sister upon death. Okay, so a will can be coupled with other beneficiary designations or beneficiary deeds to avoid probate. Where the complication comes in is, let's say she says, well, but if my sister predeceases me, her kids are 10 and 12, and I'd like everything to be, distributed to them when they turn 25. We just crossed over the bridge that we need a trust, because we can't do that among those payable on death and beneficiary deeds. So let's talk about what is probate. I feel like my entire job is trying to avoid probate. And people sometimes wonder, taking a step back, why do we really want to avoid probate? Now, one thing to keep in mind that's very important is the threshold for probate in Arizona is extremely low. I actually haven't seen this dollar amount has not changed in over 15 years. You only can have $75,000 of personal property in your name before triggering probate. You have a car worth 40, bank account worth 30 grand, and no beneficiary designations on either, you just went into probate. I always say though, think of, personal property is included in that, so your household furnishings, jewelry, but if you think about it, when you think about who's going to require probate, again, it's that third party, right? No one's going to, if someone has $100,000 of jewelry and that's going to your child, the child's not going to say, I can't accept this without going to court. I mean, it's who's going to stop the process, and that would be a bank, a title company, the DMV. Cars trigger probate a lot, by the way. And one of the ways to avoid that, there's a great beneficiary designation form right online for your car. And you can have it notarized or go into the DMV. But I see cars trigger, we've done a great job, let's say, of putting all the assets in the trust, but someone has $100,000 worth of vehicles. And then we have to go through probate. So what is that? So probate in Arizona, or probate in general, means proving the will through a court proceeding. And there's actually a formal process and an informal process. And the difference between the two is the one document in your estate plan where the original is extremely important is your last will and testament. If you don't have an original will, that's where you have to go through formal probate. If you have the original will, it's informal. But essentially, the personal representative gets appointed. There's an inventory of all assets, notice to creditors are paid, all of your final expenses and administrative expenses are paid, then the property is distributed. When I'll give you an example, let's say everything's in the trust and we have these cars triggering probate. At our firm, to keep costs down, generally speaking, paralegals do probate process. We have very experienced paralegals, but Still keeping it down, I'd say a simple probate is $10,000 and probably 9 months to a year. So we don't want you to have to spend the money or time going through that. It slows everything down. One thing to be mindful, I know we have a lot of people that are from other states, maybe came out here in Arizona. If someone has land in Wisconsin and doesn't have a trust or other mechanisms to avoid probate, they're going to have, and they now live in Arizona, they're going to have to go through probate in Wisconsin and Arizona. And other states aren't as friendly as ours with our laws. Back east, for example, in Arizona, probate is just hourly as far as compensation to attorneys. Back east in New Jersey, New York, and a lot of other states, lawyers get a percentage of the probate. And so it's statutory by law. So on a $4 million estate, I had this client come from New Jersey. They had a $4 million estate and just a last will. And my rough calculation was the attorney's fees on that would be about $150,000 that they were, so I mean, you really need to be mindful. And the 2 state triggering probate can get very expensive. So, okay, so what is a living trust? And I think there's sometimes a misconception that you have to have a very large estate to have a living trust. I think you can see from the examples, you know, the 2 things that in my mind cross over the bridge where most people need a trust. Number 1, minor children or grandkids that you want to provide for. We generally don't give children the assets until at least 25. So we're going to need a living trust to do that. There is another type of trust that can be done under a will, under a last will. That's called a testamentary trust. And I have probably only done 2 in the last 10 years. And the reason being is that in order for that testamentary trust to be set up, you have to go through probate. But an example of why we've done it, let's say I have a client who's flying to Europe tomorrow, and they called me today. Please call your lawyer before the day before a trip. But anyway, I've seen it happen, or someone's going in for a surgery, and they say, I'm not going to have time to transfer my assets to the trust anyway. So we do that as just kind of a little fail-safe. But a revocable living trust, if your assets go into that trust, because it's created during your lifetime, it avoids probate. So what that means is you're going to be what we call the grantor or the trustor, the one creating the trust. Think of yourself as the primary beneficiary of that trust as well, and you're going to be the trustee. So I think there's times people think, oh, well, am I giving my assets to my children or the charity now? No, you can use everything during your lifetime. You can sell everything during your lifetime. It's just that whatever is left when you pass away will go to the beneficiaries, how you've instructed in your trust. Further than that, another thing that a revocable living trust is actually very helpful for, we think about death a lot, but incapacity is just as important. And if you have your assets in a revocable living trust and you're incapacitated, your successor trustee steps in and helps manage those assets. So again, properly funded assets will avoid probate. We spend a lot of time in my practice helping people transfer their assets. There are some lawyers who will just give you what we call a funding memo and tell you to go home and do that. And in my experience, I just find that people don't take the time to do that or are very confused. So we really hold people's hand. The same day you set up a trust, we transfer your home to the trust. It doesn't matter if you have a mortgage. There's a law that says that the certain transfers, if you have a mortgage, for example, if you transfer a property to an LLC, technically that could trigger the due on sale clause because you're putting it in a different entity. There's a federal law that says that the government and the lending institutions understand you're doing this for estate planning purposes, so that's not a problem. So we transfer your home that day. We will also do a bill of sale to transfer your personal property because, again, the $100,000 of jewelry doesn't have to pass through a brokerage house, but we still want to make it clear that that's in the trust. We give you the beneficiary designation names or forms for the cars. We assign your business interest to your trust, everything we can think of. What we can't do, but we can give you guidance on, is the bank. Now, the bank accounts, you generally have to take a copy of the trust into the bank, meet with someone, and change your bank signature card. IRAs and life insurance, again, we can advise you as to how to fill out those payable on death forms, but regardless if I put your IRA or your life insurance on a schedule of my trust, that means nothing. What does the company have on file with their paperwork if something happens to you? Does anybody have any questions about any of that? No?
Yes, I do.
Okay.
My sister has quite a amount of money on 401k, and she put me as a beneficiary. That we don't have living trust, we don't have testament, we have nothing, zero. And I am 77, she is 10 years older, and it is huge mistake and neglect. My question is, the 401k of FED should be put in the living trust, correct?
Okay, so that's a good question. The question is, should a 401k be put into a living trust? I separate assets into two buckets. I think of, let's talk about the type or Schedule A assets, because we use a Schedule A and a Schedule B. So Schedule A assets are going to be your home, your bank accounts, your business interests, any real estate, any personal property. Schedule A assets should be owned by your trust, okay? So Schedule A, your real estate, your bank accounts, all of those should be owned by your trust. Schedule B are a little bit different. Your 401k is going to go on what I call Schedule B. Your 401k should not be owned by your trust. The beneficiary should be your trust. And if you're married, generally speaking, and it's actually by law, your spouse should be the primary beneficiary of your 401k or IRA. And the trust should be what we call the contingent or backup. Okay, so Schedule B assets are not owned by your trust, it's your trust is the beneficiary. Life insurance is also what I call a Schedule B asset. If you want, so in my case, I'm married, I have an 8-year-old son. Because he's only 8, now my 401k or IRA, my husband's primary, my trust is backup, because if something happens to both of us, then my 401k IRA would be distributed per the terms of my trust. Life insurance, same thing. Generally speaking, the spouse would be the primary beneficiary, and the trust would be the backup beneficiary or contingent. And that's, Schedule B is more for things that you want, where you're going to name the trust as the beneficiary. So it's a little bit different. Keep in mind the trust is revocable and amendable until you die, and irrevocable, of course, upon your death. If you're a married couple, I don't want to get too into the weeds, but there's 2 different types of trusts that are really important, and this is usually one of the reasons people need to pull out their trust again and look to see if you need to have it updated. If you're married, make a note. There's what we call a single pot trust or an AB trust, and they're very different. You might need someone to look at it to tell you it's not that clear, but essentially, if you're reading through the trust and you see that part of it becomes irrevocable on the death of the first spouse, that's an AB trust. Now, there's 2 reasons people have AB trusts. One are estate tax considerations, and the second would be a blended family. If we had a blended family and the first spouse dies and had children from a prior marriage, then they would want to make sure that those children are provided for. The second reason is estate tax considerations. What I see happen a lot is back in, let's say, the year 2001, the estate tax exemption was only $675,000. Okay, it's very low per person. That means that if you had more than $675,000, a single person, they were going to pay estate taxes when they died, if planning wasn't done to avoid it. So one of the common uses was the AB trust. It provided some estate tax savings. Guess what the exemption is now? $12,920,000. So I have a lot of people come into my office and have an AV trust, and they maybe have $1 million or $2 million. And I'm not saying that's small, I'm just saying they don't need the AV trust. And what they don't understand is that, and so usually that's one of the first things I look at on an estate plan update. Okay, is there another reason that you want to have it? If not, when the first spouse dies, all of the assets have to be valued and split into 2 buckets. And a tax return for the irrevocable trust has to be filed every year. Again, accounting and legal fees, I'd say at least $5,000 to $10,000. So if you don't need it, it's a good time to simplify your trust.
I read that 12,292,000 exemption is actually going to drop.
Yes. Yeah. Good question. The question was, I heard that the exemption is going to drop. And so that is correct. It is going to drop, but it's still going to be pretty high. So if Congress does nothing, the exemption doubled basically when the Tax Cut and Job Act came out in 2017. It doubled. And what's happened is because inflation's so high, last year it was 12,060,000. It went up 12,920,000, almost $1 million because of inflation. So, but if Congress could always make a plan to change it. There was a plan in 2020 where it was going to be 3.5 million per person. It didn't happen. We talked to a lot of experts in this area around the country who are very in the know. And the consensus is right now that Congress isn't doing anything. But if they do nothing, the Tax Cut and Job Act sunsets January 1st, 2026. And what happens is it's going to go back down to 5 million per person, but indexed for inflation. So we estimate it will be 7 million per person in 2026. Right now, for people that have large estates, that's one of the reasons we're so busy, is that when we have someone right now who has a $25 million estate, or keep in mind, married couple, we're going to go to 14 million. If they have 17 million, we are going to be extremely busy in the next 2 years doing gifting, charitable trusts, different techniques. You can take advantage of that exemption before it goes down. But to your point, 14 million is still very high. So for most, I'd say 98% of the population, if you're still going to be under 14 million, we don't need the AV trust. To get a little bit more into the weeds of something that's really important, another thing that didn't exist when all of these AV trusts were done in the early 2000s, in 2012, there's something that was developed called, or put into law called portability, and that's really important. So let's say I have a client that comes in and they say, well, this just feels uncertain. I don't know, it could really go down, and what if I'm incapacitated and I remove my AV trust? The law today is if you can preserve, if your spouse passes away, you have 5 years, it used to be 2, you have 5 years to file an estate tax return, Form 706, and preserve your deceased spouse's unused exemption. So I'll give you an example. Let's say someone passed away next year before it sunsets, and it's now 13.5 million. And they say, you know what, I don't know, this is kind of hard because, I have a $10 million estate, I don't have an issue today, but I hope to live a long time. What if it goes down to 3 million and, this exemption? It's like an insurance policy. We go ahead, file the estate tax return, then surviving spouse will always have her spouse's $13 million preserved. So it's a very individual, threshold of what we're doing, but that's really important and it could even be someone maybe even with 5 million might say they want to do it. Below that, maybe not, but portability is really important. I actually just had someone come in who they just changed the deadline from 2 years to 5 years to file the return, and I had someone come in 2 months before it was due with a lot of assets. And she said, can you please help me? We got it done 2 days before the 5-year deadline. I didn't want to find out what would happen with the IRS if we missed it. Of course, I can't miss the deadline, but we got it done right in time. So 5 years is the new rule.
downside, if you don't do AB, you remarry. Everybody who is a beneficiary, our children, grandchildren, can be frozen out every dollar.
Okay, so the comment was the downside if you remarry and you don't do an AB trust. So let's talk about that. That's an important consideration. When someone gets divorced, your trust is actually going to be revoked. So it's going to go away. So if you have an AB trust and you get divorced, it's actually going to be revoked, and then you each set up your own. But your point is an important one, where in a blended family situation, or I have some clients who just say, you know what, I mean, I don't know, I'm in charge of the finances, and I'm really worried that my husband or wife, if something were to happen to me, there could be some undue influence, and someone could convince them to change everything. So I do have people who don't have blended families or don't have estate tax considerations. If they feel they have a spouse that, or there's someone else out there that they could be vulnerable, they might say, you know what, it's worth the $5,000 or $10,000. My peace of mind, it just makes me feel better. It is, there's a lot of considerations. It's a very involved conversation that I have with people, but I always want them to understand the difference. So it's very important. So the benefits of a trust: no probate, of course, again, with the disclaimer, no probate if properly funded. All of your assets need to go into your trust. You can keep the $75,000 each out of it. A lot of times I have people, okay, my checking account stays at 10 grand, my car's worth 30 grand. Again, not too worried about the personal property. That's okay. Again, it's not a public court proceeding, so much easier and obviously private, which is very important. Also, again, we always think about death instead of incapacity, but the trust, if something were to happen to you, your successor trustee is also the trustee during any incapacity. So if you didn't have the trust and you didn't have a financial power of attorney, you would need a conservatorship of someone to manage your assets. So that eliminates that. Trustees' fees. So who you pick as successor trustee, if it's just you or after husband and wife, very important decision. There are corporate trustees, those are usually more appropriate for larger estates. We also use licensed fiduciaries quite a bit. Someone says, I don't really have any family that I want to serve in this role. There's licensed fiduciaries that will do that. CPAs make wonderful trustees if they're willing to do it. It's a lot of liability. I get people all the time that ask me if I'll do it. Some law firms do. We try to shy away from it. It seems a little self-serving, even if a client wants us to name them. Also our malpractice insurance. So it's an important role, and because of that, trustees are entitled to compensation. Right? It says reasonable compensation, the law, based on skills and experience. So if you had a person who's not an accountant or a lawyer acting in this role, generally speaking, I'd say somewhere between $50 to $100 an hour is about standard of what they could take. If you have a lawyer or an accountant, they can charge their hourly rate. If you have a trust company, they're usually going to take basis points off the size of your estate. So those are all important considerations. Now again, sometimes if kids are serving, they don't take the fee. They could, but if everything's going to two children and one of them just sees it as, part of their job to do. So benefits of an estate plan, of course, are avoiding probate, providing for incapacity. Usually an estate plan package, I would call it, that we're putting together, we usually don't piecemeal these documents. It's your last will and testament, it's your revocable living trust, and it's also your financial power of attorney and medical power of attorney. Those documents are very important to name. If you can't make medical or financial decisions, who can do that for you? Asset protection. If you are a single person or it's a married couple and both parties have passed away, when the trust is irrevocable, it does have asset protection if drafted properly. So if you have a trust, you pass away, and it's for, let's say in my instance, my husband and I passed away, it's for our son, and it says that it's for my son's health, education, maintenance, and support. The reason you see those words, the IRS calls that an ascertainable standard. That has creditor protection. Paying the IRS or paying a car accident claim is not for my son's health, education, maintenance, and support. So it must be drafted properly. Further than that, if everything goes out right to a child at the age of 30 and they got into a car accident at 31, again, won't have that asset protection. But instead, if you say my child is his own trustee for health, education, maintenance, and support, then it will. So there's really important decisions. That's one of the other things we look at. Generally speaking, back in the day, it used to be more that the trusts were drafted where at the age of 25, a third to the child, 30, 2/3, 35, everything outright. Now we move over to usually naming the children as their own trustee for health, education, maintenance, and support. I would say the larger the estate, the more it gives rise to it. Again, it's an insurance policy. A lot of my partners, say even 200,000. Would you not want to protect that? Why not name the child as trustee? And it's not that we don't trust the children, it's just that we can't, again, control whatever could happen in someone's life. And also, I think we've talked about, most of this. It's the most efficient way, to pass things on to your beneficiaries. And also, there's a lot of tax considerations as well. So that's one of the things I'll touch on just real quick on that. A lot of times people say, I'm going to add my child to my bank account now. One that's a better example, I'm going to add my child to my deed right now. I'm not going to wait till later. I'm just going to put her on there right now. And I say, don't do it. And one of the things is that you have to keep in mind, a very powerful thing you have is the step-up in basis on assets at date of death. So if you buy a house worth $100,000 and now it's worth $1 million, if your child inherits that and it's worth $2 million when you die, their basis for tax purposes is the $2 million. It gets a step-up in basis at date of death. Instead, so she decides, I don't want to keep the house, I'm going to sell it. There's no capital gains. Instead, you add her to title now. You're going to say, I'm going to beat the process and just do it now. Joint tenancy, rights of survivorship, something happens to me, it goes to her. Okay, well, you're 50-50 owners now. The house was worth $100,000, now it's worth $1 million. She owns 50% of that house, and guess what her basis is? $50,000. She steps into your shoes. Now, let's say, she inherits it and she wants to sell it. She's going to be paying a lot of capital gains. So we only do the gifting to family members if you have a taxable estate. Then that's where we weigh estate taxes versus income taxes, and it gets complicated. Charitable giving, very different. You should do that during your lifetime, and we talked about a lot of those benefits too.
Could you say something about the charity, about the donations that would be tax efficient?
Okay, so the question was, could I talk about donations that would be tax efficient to charities? There are so many great tools that I know we touched on a little bit earlier, Jacob did, but some of the things that we use at our firm that we commonly do, a great asset to give to charity, and I think you talked about that a little bit, is your IRA. When we see an IRA that has not been taxed and your children are going to have to take it out over 10 years, and the new rule under the Secure Act is you take it out over 10 years, pay all the taxes. Why not give that IRA to charity? That's a very tax efficient plan. The others would be charitable remainder uni trusts. We do those quite a bit, and charitable lead annuity trusts. Again, the difference between the two is who's getting one. Either the charity's getting the annuity or they're getting the remainder, and that's actually a great way to I don't want to say avoid, but sometimes if there's a big capital gain event, you're selling a business, we look at the charitable remainder uni trust to see if there's a way that we can minimize some taxes in a legal and efficient way. So again, cash, a charity is going to be or the church, very grateful for your donation. But I think taking that step of what Jacob said and saying, what can I do as far as making it efficient? I also think the bundling is a really good idea too. So again, Tax Cut and Job Act doubled our standard deduction. where a lot of people used to itemize, now they're not itemizing as much. So what charities are saying is, okay, maybe take the standard deduction this year, bundle all your giving in year 2, and itemize so that you get the benefit of it. Any other questions?
Yes. What would be the best? I have additional house in Michigan that is in process of selling, but not sold. If I would like to take the headache from myself and say, I am giving you the house, it means to the church. I am giving the house to the church and deal with it. You want to do something with this house, to sell or so. How do we call this? I call this gift to the church or charitable gift. How we call this? And what would be also, because if you are giving something, you want that the whole asset maximum will go to the church. That I don't want. I'm sorry. Yesterday was the homily about this to give to Uncle Sam. And I want that the maximum would go to the church. How to do this to avoid this?
Yes, great question. Thank you. Can St. John Vianney accept homes in other states? Father?
Yes, this is from another state.
Usually not. The Catholic Community Foundation can accept property, real property, as a gift. If it hasn't already sold, then we can accept it. We will liquidate it. We will tell you how much we were able to sell it for. You get to call however much we're able to sell it for a gift. And then you can tell the Catholic Community Foundation, I want this to go to St. John Vianney's Building Fund, or I want this to go to St. Vincent de Paul, or wherever, whatever organization is on your heart. That's the simple way. If it's already been sold, at that point we can't do anything except.
It will be so. You'll learn from later, but I don't want to bother myself with this. I want to take the stress away from it. So I say, this is the house, this is the property, please take this and do something with this.
Yep, exactly. Pretty simple. Yes.
Yeah, I think you're saying you have to facilitate that.
Yes, I understood that I have to sell this and bring the money or.
I'm sorry, I'll clarify. So there are 2 options here. You can either sell the house and then make a gift of the actual cash that you have on hand, or before it's sold, you can reach out to us and say, I'd like to gift this property to the Catholic Church, specifically to XYZ parish or XYZ organization. We will say, okay, there'll be some back and forth, and then we will find a seller. We will facilitate everything for you. Yes. Yes, sir.
I was going to say, if somebody were to give the house during their lifetime, could they require a life estate so they can continue to live in it? Would that be of any benefit to the church or not? Because you wouldn't be able to sell it, would you?
We would have to take that on a case-by-case basis. Come talk to me after, and we'll see if that's possible. Yes.
I think that's the thing with real estate, you have to know whether your 501c3 can actually deal with those things. I'm not involved in 501c3, we don't have a capability of dealing with real estate. So that's where our foundation comes in, because they've got people that
For sure.
The comment was most 501c3s are not able to accept real estate. The foundation, being the financial engine for the diocese, is able to do that generally. There's exceptions, there's very specific situations. If you do have a situation like that, come talk to me. We'll see how we can make it work. Yes.
I'm sorry. If I will take the money, right? I will sell it. I have the money. But still the house was sold with the intention of giving to the church. And if I would like, may I divide this, for instance, 50,000 every year to gain for myself the charitable donation from my annual taxes, because I can claim every year charitable donations. But if I would like the amount of money divide every year to give, for instance, 50,000, may I do this, or I have to give this whole amount, the whole amount at once?
If you make a gift,
But
50,000.
every time, if, okay, the charity is different than the
Yeah.
family, yeah.
Other questions or concerns there? Okay, thank you all very much for your time. Lisa, thank you for your time. Lisa said she'd be happy to stick around for a few moments after and answer any questions you have. I will say that we also have another estate planning attorney on our board who said he'd be happy to take consultations. So I have his card on my desk. He's very good. I've used him myself. Anyone has a need for a consultation with an estate planning attorney, short term, next couple minutes, talk to Lisa. If you need to sit on it for a little bit, take Ryan's card. It's on my desk. We'd be happy to assist you. All right. Thank you so much.